This informational video is adapted from Legacy Assurance Plan's vast library of articles about estate planning. No other professional organization or company focusing on estate planning offers the lifetime of services that Legacy Plan does. Estate planning can seem overwhelming. It doesn't have to be. Now stay tuned for this article based on our experience and expertise in all things estate planning. Does dementia equate to incapacity? Here's important information you need to know. When someone is diagnosed with Alzheimer's disease or dementia, a question that often arises is whether that individual is now automatically deemed legally incapacitated or of unsound mind. There are also concerns about an individual's ability to function and handle everyday issues and decisions. This article provides answers and insights to these important issues. In reality, when someone is diagnosed with Alzheimer's disease or dementia, they are not immediately considered incapacitated or of unsound mind. A legal determination of whether someone is incapacitated needs to be made by a court. There is no presumption or immediate trigger based solely on a medical diagnosis. What is the process of legally deciding incapacitation? A legal finding of incapacitation generally occurs after a petition has been filed in a court, seeking a determination be made by a judge. The court proceedings is known as guardianship. The individual who filed the petition and the individual alleged to be incapacitated will need to be represented by counsel. It is quite common for the court to utilize an examining committee that will meet with the individual and prepare a report for the judge as to their opinion of the individual's capacity to make certain decisions. If all members of the committee determine that the individual lacks capacity, the judge will find that that individual is legally incapacitated and enter an official order. However, even when an incapacitation order is entered, it does not mean a guardian will automatically be appointed. For example, if there are legal documents in place, powers of attorney and/or healthcare directives, that may enable someone to manage the affairs of the incapacitated person. The court will likely respect the terms of those legal documents. What are the ramifications of a court declaring someone to be incapacitated? When someone is declared completely incapacitated by a court, it's a life-altering decision that has significant ramifications. For example, that individual will lose the right to make any decisions regarding their finances or personal welfare, including where they reside, the medical care they receive, and how their money is spent or distributed. It is worth noting that someone can be deemed partially incapacitated, which means someone may lose their ability to make certain decisions, such as what to do with their money. Dementia is a growing issue across the globe. It's important to address the issue of dementia diagnosis in your estate plan. Why? Because more and more people are being diagnosed with dementia. For example, a dementia diagnosis is made every 3 seconds across the globe. There are close to 50 million people worldwide living with dementia, and this number is expected to almost double every 20 years. That means there could be up to 75 million people living with dementia in 2030 and 131.5 million in 2050, according to Alzheimer's Disease International. The total estimated worldwide cost of dementia is in excess of $1 trillion, which includes the cost associated with informal care, i.e., unpaid care provided by a loved one, direct costs of social care, and the direct cost of medical treatment, i.e., the cost of treating dementia and other conditions in primary and secondary care. Is mild cognitive impairment the same as having dementia? If you are diagnosed with mild cognitive impairment, it does not mean that you have full-blown dementia. It also does not mean that you lack the capacity to create certain legal documents, like a revocable trust or a living will. Nevertheless, it's important to be proactive and take steps to protect yourself and your estate. There are certain proactive steps you can take to protect your estate and your rights in the event that you were to become incapacitated. For example, you should consider speaking to an experienced estate planning professional to help draft an advance directive, living will, which will enable you to appoint a trusted individual to make important healthcare decisions on your behalf when you are unable to due to incapacity. Another step you can take is establishing a revocable living trust. This type of trust can be set up to allow you to control the assets in the trust and transfer control automatically to a successor trustee appointed by you if you were to be deemed incapacitated. Another great aspect of a revocable trust is that you have a tremendous amount of power and flexibility over the terms of the trust. For example, you could potentially be able to define what is considered incapacitated in the context of a living trust. Are there other ways intervention can be triggered? If you are concerned about a loved one's mental capacity to handle certain affairs, but you do not want to haul them into court and go through a contentious and impersonal legal process, there are other ways to achieve intervention in a more personal way. For example, it may be possible for the loved one to see their physician, and the physician drafts a letter stating that the individual is no longer able to make certain decisions related to healthcare, finances, etc. Putting this assessment in writing and in the patient's medical records can actually trigger a healthcare surrogate's authority to act on behalf of the loved one. In other instances, this letter can be used to enable a successor trustee under a trust to take over financial management of a trust account. However, it's important to understand that this type of letter does not establish that an individual is legally incapacitated. How do I create an estate plan? There are numerous options and scenarios to consider when developing an estate plan that protects your legacy and achieves your objectives. And important decisions should be made with the advice of qualified lawyers and financial experts. Membership with Legacy Assurance Plan provides members with valuable resources and guidance to develop comprehensive estate plans that take life's contingencies into consideration and leave a positive impact for generations to come. Legacy Assurance Plan members also receive peace of mind that a trusted team of experienced professionals will assist them in developing legal, financial, and tax strategies that will meet their needs today and for years to come through our periodic reviews.